Yes, Mr. Purtis.
Well, it's, my lady, as you're aware, I'm here with Mr. Tappin on behalf of Mr. Speck, a late addition to the team, appear for the respondent.
I'm very sorry to mention, I'm having slight difficulty hearing you.
I beg your pardon.
These things don't magnify your voice, so if you could just keep your voice up a little bit, thank you.
I will try, thank you. As you're aware, this is an appeal from the Court of Appeal's reversal of the decision of the late Mr. Justice Henry Carr. Mr. Justice Carr held the patents in issue invalid under Section 72(1)(c) of the Patents Act 1977, which implements the requirements of sufficiency of description under Article 83 of the European Patent Convention. Whilst there were and are two patents in issue in this case, I'm going to concentrate, as we did in our written case, on Claim 1 of the 163 patent, which is Tab 8 of Core Bundle 2, MS 393 onwards. It's accepted by the respondents that if our arguments succeed on that claim, then claims 5 and 6 of the 287 patent, which are the other claims infringed in this action, would fall on the same basis. And as we noted in our case, whilst there are good arguments against claim 1 of the 287 patent as well, they are somewhat different in nature from the arguments which we pursue in relation to claim 1 of 163 and 5 and 6 of 287, and my clients don't use the claimed method. So we're not inviting you on this appeal to revoke any claims of 287 other than 5 and 6. My lords, my lady, in a nutshell, our submission is very simple. The law of sufficiency requires that to justify a patent monopoly, the patentee must provide enough information to ensure that the skilled reader of the patent at the priority date can, without the need to make further inventions, and using only the disclosure of the patent and his own common general knowledge, fully implement the invention across the whole scope of the claimed monopoly. Put perhaps more succinctly in the words typically of Lord Justice Jacob in Novartis and Johnson & Johnson, in a passage quoted by the Court of Appeal that we'll come to a little later, can the skilled person readily perform the invention over the whole area claimed without undue burden and without needing inventive skill? The consequence of that obligation is that where the claimed monopoly defines a wide range of products, sufficient information must be provided to make products across the whole range. And if only one limited part of that range covered by the claim was in fact made available to the skilled reader, then the claim will be invalid unless restricted by amendment. In the present case, on the findings, explicit findings of the Court of Appeal, only a subset, and as we pointed out, a pretty small subset, of the claimed range of products was in fact available at the priority date to the skilled reader without making further inventions or without exercising undue effort, and applying the test as expressed by Lord Justice Jacob, or as commonly understood from many of the cases that you're going to look at, the claim on that basis was, in our submission, plainly invalid and that should have been the end of the matter on the application of the established principles. We submit that the Court of Appeal wrongly held otherwise, and they did so based on an incorrect and somewhat convoluted account of the law, which, as we submit, simply cannot be squared with the consistent jurisprudence of the technical boards of appeal in the European Patent Office, approved at the highest level in the United Kingdom, on the need to enable across the scope of the claim. It's apparent, we submit from the judgment, that the Court of Appeal were seduced perhaps by the success of later products made by Regeneron based on the underlying idea behind the patent. And perhaps they were also seduced by considerations of the originality and radical nature which they perceived to lie in the idea, into the belief that they should reward Regeneron by giving them a broad monopoly, despite the severe limitations of what was actually enabled. And you will have seen similar arguments suffusing the respondent's written case. We submit such considerations need to be resisted like the song of the sirens. They are simply not relevant to the question of enablement at the date of the patent. None of Regeneron's later products were made using the methods taught in the patent, or indeed the common general knowledge method held by the Court of Appeal to have been feasible. Whilst they may have implemented the underlying idea, they required new and highly inventive techniques, neither disclosed nor available to the skilled person at the date of the patent. If Regeneron, of course, had wanted to protect its later developments, it could have done so when it was able and willing to disclose those developments to the art and explain how to implement them. That's our case on the law and how it applies to the facts in a nutshell. My next section was going to delve into the relevant technical facts underlying the relevant findings in this case, including the teaching of the patent. I'm very conscious that you have already seen at least two, possibly three accounts of the relevant background technical information in the original judgment of Sir Henry Carr and the judgment of the Court of Appeal, and also in the technical primer, which is in your core volume. However, I think it may nonetheless be of assistance and put into context some of my later submissions for me to run through what we say is important, but obviously if at some point I'm being oversimplistic or teaching my grandmother to suck eggs, then please, and no doubt you will tell me accordingly. The invention, as you're aware, concerns transgenic mice designed to produce antibodies. Antibodies are proteins secreted by particular mammalian cells called B cells when those cells detect the presence of an antigen, and the proteins serve to defend the mammal against the antigen. To successfully defend against a wide range of potentially harmful antigens, the body has to be able to generate a huge range of different antibodies. And precisely how that is done in mammalian bodies is perhaps one of the miracles of evolution. The process of creation of a mature B cell in the body involves the combination of various elements present in the genome in a new way so as to create a unique receptor on the surface of the cell. The receptors project from the surface of the cell, and depending on the particular genetic makeup of the receptor, may have an affinity for an antigen which has invaded the body. An antigen is a kind of toxin given off by a virus. Once activated by binding to the antigen, the B cells can start to divide and multiply, increasing the number of cells that have the appropriate receptor for the antigen which has been detected. Other B cells become plasma cells that secrete molecules known as antibodies, which are essentially identical in structure to the receptor. And the recombination of genetic material in the B cells to provide the necessary variety of antibodies and receptors is known as somatic gene rearrangement, or VDJ recombination, for reasons which will become apparent. Now, just to illustrate what's going on, one can find in the judgment of the Court of Appeal, indeed in many other places in this case, a picture of a typical configuration of an antibody at paragraph 13 of the judgment, which is in C2 tab 2. It's MS177 if you're in the electronic bundle, and it's taken in fact from the primer, which is at C2 tab 8 if you've got that, MS437.
You say 437?
437 of the primer. And what we see here are white elements and purple elements, if you've got the picture that I'm looking at. Mm-hmm. The white elements are the parts which don't rearrange, known as the constant domains, and are duly identified as such in the figure. And the purple elements are the parts that provide the variety between B cells, known as the variable domains. And this drawing shows how the receptor or antibody molecule, as it may become, combines two heavy chains, which are the two middle chains, so the two vertical lines then projecting off to the right, with two light chains, which are the strips top right and top left hanging off the side of the heavy chains. For completeness, for any given antibody, the heavy chains will be identical to each other, as will be the light chains, but the light chains can be either kappa or lambda type. A point that probably isn't particularly relevant to the rest of the analysis. For the purpose of this hearing, we will concentrate generally on the ingredients of the heavy chains and the way in which somatic recombination occurs there, although the 163 patent actually requires both heavy and light chains to have been. The light chains are produced, in fact, by a very similar mechanism and themselves add considerably to the diversity of the antibodies. Now, the chosen instruments of research in this field are primarily mice, and the claims are limited, as you've seen, to mice, and in particular transgenic mice. Now, as a starting point, if you discover that by researching using mice, you can generate antibodies in the mouse in a lab by exposing the mouse to a harmful antigen, you may find that you can observe which of the antibodies, and therefore which of the B cells, is successful in fighting off the antigen that you're testing. And if you can do that, it may then be possible to produce large quantities of the relevant antibody and incorporate it into a drug. But there's a fly in the ointment in using ordinary mice to produce murine antibodies to fight a particular antigen. This is that the human body seeks to repel the antibody, which it sees as just as foreign as the antigen that it's designed to fight. And you'll have seen references in this case and the judgments to the negative response given by humans to murine antibodies, known as HAMA, H-A-M-A, the human anti-mouse response. Now, to try and avoid that problem, it had been realized long before the priority date that you could cut out the middleman, as it were, perhaps the middle mouse, by transgenically altering the mouse so that it would produce B cells that secreted human antibodies rather than murine antibodies. And of course, a human antibody would not be rejected by the HAMA response. To achieve that creation of a transgenic mouse, you have to find some way of introducing the human immunoglobulin segments of the kind we're looking at in these, the human immunoglobulin segments into a mouse genome. This can, in theory, be done either randomly or by way of targeting. And it's worth just explaining those two concepts. A random introduction into the mouse genome is done essentially by introducing the human segments into a nucleus and hoping or expecting that they will occasionally get incorporated somewhere in the chromosomes of the mouse at unpredictable places. Targeting is a much more difficult process which seeks to insert the human DNA in the specific places in the mouse genome where the equivalent mouse DNA, that is to say, the immunoglobulin DNA, can be found in the particular chromosomes at the particular locus. Now, because of the difficulties of that DNA engineering process, at the priority date, only tiny segments of DNA were able to be replaced in this manner by targeted methods, as the trial judge found, and I'll take you to it, but I'll give you the note, give you the reference for your note at paragraphs 66 to 68 of judgment. So that's the engineering process that we're concerned with. At this point, I need to discuss in a little more detail the question of somatic recombination. Somatic means the cells in the body as opposed to the germline cells with the germline DNA. As I've said, the human body needs to generate a huge variety of antibodies to maximize its chances of fighting off antigens, and therefore needs to create a huge range of different B cell receptors which will have affinity for a wide range of potential antigens. And the manner in which that's done from a single set of ingredients in a specific order in the germline DNA of an individual during the development of these B cells can be seen best from the account given in Mr. Justice Carr's judgment, which is C2 tab 5, pages 8 to 9, and I think that is MS 27. I'm sorry, pages 8.
270, 271.
Pages 8 to 9 in the core volume 2, MS 270 to 271.
Thank you.
And what you will see set out in the diagram in paragraph 19 are the various coding segments which are located in the germline DNA of an individual. The blue ones are the C or constant region segments. Then you have the yellow ones, which are the J, I think they're orange, and I'm very good at colours, the Ds, and the ones on the left, the reds, are the V segments. V, D, and J are all what's referred to as being in the variable region. That's the purple region that we looked at in the previous diagram. Now, you'll see in brackets about 4 along if one just looks at the top line of the heavy, showing the heavy chain segments, V1, V2, VH1, VH2, VH3, and then you'll see in brackets V8N. That is there to indicate a number of V segments, obviously too large to fit on the page, which runs up to something like 125 Vs in total. There are, I think, 20 odd Ds on the same basis, and around, I think the 6 Js is correct. So one has to imagine, in fact, a great number of these segments in the germline DNA. And what the judge shows on the left-hand page, MS 270, page 8 of the judgment at the top, is schematically how the variable segments, that's the V's, D's and J's in the heavy chain, are combined together randomly in the development of each B cell to form DNA containing a single V segment, a single D and a single J. And as that figure shows from top to bottom, how in the development of the B cell the recombination occurs. But what's important to realise is that this can occur by joining together any V with any D with any J on a random basis. And that is how, as one can readily imagine, even though one starts off with a single sequence of DNA with 125 Vs, 20 odd Ds, 6 Js, one can end up with millions of different B cells by combining together randomly individual Vs, Ds and Js. As someone points out in the expert evidence, imagine that the sheer amount of DNA that would be necessary in the germline to code for the same thing directly without involving random combination of cells would be absolutely enormous and far too big to fit in a human chromosome. So once that variable set of segments has been developed, and you'll see by the bottom of the diagram on the left, it has been translated into a particular combination of V's, D's and J's. That combines then with the C segments to form the heavy chain part of the B cell receptor, and you will recognise that general shape that you can see at the bottom of the diagram on the left-hand side as reflecting the shape of the receptor that we saw in the earlier diagram. Much the same happens when one creates the light chain that we saw hanging off the side of the heavy chains, only this time it's created in the variable region solely by V and J segments, not the D ones. And obviously, by combining the randomly created heavy chain with a randomly created light chain, you add to the potential diversity. And it's this process of rearrangement of the variable gene segments which is the magic formula that enables mammalian bodies to fight off a huge range of antigens. Now, because all the segments are different, as I explained, each possible combination of segments produces a different antibody, and it was well understood at the date of the patent that the wider the range of antibodies could be achieved, the better the chance of producing one which is successful against a particular antigen. And the ability to produce this vast range of antibodies from a single set of V's, D's and J's in the germline DNA is what is known in the art as combinatorial diversity, which is a phrase we will come back to. Now, from the human immunoglobulin gene locus, the potential number of potential combinations and therefore different antibodies is around 1.5 million. Take that number from the primer, which is at core 2, tab 8, at 5.23. I wasn't going to take you to it. MS444. So if one's creating a transgenic mouse, which one wants to generate as many different antibodies as possible, the more variable segments, and in particular the more V segments, which there are so many, which can be incorporated into the genome of the mouse, the better. And one of the key facts in this case is that it was well understood at the priority date that the key goal of transgenic mice created for the purpose of generating antibodies was to create a mouse that incorporated substantially all the human V segment into the mouse genome, so that the mouse would perform as well as a human, a natural human, in producing a huge range of antibodies. And we've set out the quotes from both experts on this matter in our written case, which you might want to turn up at this point at CV1, tab 6, that's MS 90, paragraphs 84 to 85. The end of 84 is Kymab's witness, Professor Howard. The key goal was to deliver essentially all the human variable segments, not least because the full extent of the repertoire and affinities that could be obtained by transgenic animals have not been fully explored. And similarly, Professor Plou, I'll be corrected if that's wrong, Pleu, I'm told. The dominant view at the priority date was the more human gene segments that were inserted into the trans loci, the better the human antibody expression was likely to be. At the priority date, it was known that with a single V and a complete set of Ds and Js, one could create a somewhat diverse but incomplete repertoire of antibodies. So it was appreciated that having many V genes was better than having only a few. And the Court of Appeal accepted this perhaps not surprising fact at paragraph 259 of their judgment, which is called tab 2, and the MS reference is 238.
Is,
Sorry,
your
MS
voice dropped. MS.
238.
Thank you.
Yeah. Mr. Tappin points out we've actually quoted that at paragraph 83 of our case. So. By the date of the patent, using non-targeted methods.
Right, and just in 259, where the Court of Appeal talks about a perception at the priority date, I mean, that's a perception of the true position.
It is the true position. There's a reference you may have seen in my learned friend's written case to the fact that later on, after the date of the patent, it was discovered that using a few of the most common Vs produced surprisingly good results, but no one's suggesting that gave you the complete repertoire of human antibodies, and certainly it was the state of the technical knowledge at the date of the patent, which is what matters in this case, that the more, the better. I think the answer is yes, it is still true, but it was, there's no dispute that it was completely true as set out here as of the date of the patent, so far as the skilled person, the skilled reader was concerned. By the date of the patent, using non-targeted methods, transgenic mice had been managed to be produced with a complete set of human variable constant segment, and therefore a full range of combinatorial diversity. But a problem was identified by Regeneron with those mice, which is referred to in this case as immunological sickness, although that phrase, I think, was not known at the time. The Court of Appeal refer to this phenomenon at paragraph 34 of their judgment, which is C1 tab 2, paragraph 34, MS 182. And it's quite a long passage, but in the middle of that paragraph, there's a reference to some mice being produced by a company called Medirex, of which Regeneron was a customer, and Medirex were producing fully human transgenic mice, non-targeted, which were failing to produce antibodies to targets that were known to induce antibody responses in wild-type mice. And the mice were, as they say, what has been described as immunologically sick. So these were mice that apparently had a full repertoire and should have been producing antibodies, because normal mice were known to produce antibodies to a particular antigen, but just didn't appear to be doing so. And just to avoid confusion, that's not a repertoire problem. These mice had the complete repertoire and were in principle, therefore, capable of producing any possible antibody that could ever be created. But they weren't responding as they were expected to in that particular case. And that really is the background to the invention of the patent. And the first thing to bear in mind is this patent's concerned only with targeted replacement, something which we've seen could not be achieved certainly had never been achieved on any significant scale before the priority date. In particular, it's concerned with the idea of the targeted replacement of mouse V, D, and J segments, if we're talking about the heavy chain, with human V, D, and J gene segments, but leaving the mouse constant region intact and unreplaced. And it's that concept which you've seen referred to in the judgments in this case as the reverse chimeric locus. The scale of the replacement of the variable segments, which is promised by the patentee, is explained in the trial judgment. If you've got C1 tab 5 at paragraphs 128 through to 129, and it's in MS 300 to 301. And what you will see, in fact, just after paragraph 130 is the diagram which appears in the patent of figure 4A, which is the illustration that the patent gives of the implementation of its invention. And the judge explains the achievements that are taught and promised by the patent from paragraph 128. First of all, quoting paragraph 123, and proceeds at paragraph 129 to note two correct propositions advanced both by Regeneron and by Kymab. First of all, Regeneron's pointing out that this passage in 123 specifically contemplates that replacement of the mouse locus with the human locus may be accomplished in more than one step. And secondly, Kymab pointing out that the passage contemplates replacement of a part or the whole of the mouse locus with the human locus. Both are correct.
Could you just help, whilst we've got this in our minds, what was the novelty? Was it the targeting as opposed to the random? Or was it the leaving in place of the mouse constant material?
It was, can I say, the combination of the two. It was leaving the mouse constant, but replacing the variable. Now, the point to bear in mind is that one could, of course, only do that in a targeted scheme, because you have to put the variable next to the constant. Otherwise, you can't build the heavy chains. You can't build the heavy chains because, as you've seen, they require incorporation of the VD and J with the constant. And if they're in some other chromosome miles away, that's just not going to happen.
Thank you.
So one kind of necessarily involves the other. So you might have in mind that certainly with the prior art, which was non-targeted, you couldn't have achieved that approach at all.
And in the paragraphs you've shown us,
Yes.
the judge is actually talking about the 287 patent, but are there similar explanations in...
Teaching is exactly the same.
Right.
The claims
Is the text the same? Right.
a strange way of patents. They derive from the same application. So the description is identical. It's somewhat confusing when one looks at the trial judgment and indeed the judgment of the Court of Appeal, because they tend to jump a bit from one patent to the other. But if one bears in mind that the description is identical, then it doesn't really cause a great difficulty. So I've read 128 and 129, and you get the picture of what the patent was teaching here from the diagram that the judge reproduces from the patent in paragraph 130, where you will see in the top line there a diagram of the entire human immunoglobulin heavy chain locus with the V's set out, whether that's whether that's intended to be one for each. It's certainly meant to represent the entirety of the human V's. And then you see the D's and the J's. And as you will recall, the D's, J's and the constant are all crammed at one end of the relevant locus. And the method which the patentee taught involved the use of these insertion cassettes called LTVEX. That indeed was one of the things which the patentee claimed to have invented in the description of both patents. And what the patentee is showing here is using two of these cassettes to hold considerable amounts of segments at either end of the locus. So at one end, at the right-hand end, it's holding a few of the V's, all the D's, and all the J's. And at the other end, it's holding, as you see, 200 to 300 kilobase pairs of V's. The total length, as is indicated in this figure, of the immunoglobulin section of the human genome is about 1 megabase, say 1 million bases. So as you see here, something between a fifth and a third of those are going into the LT-VEX at either end, and then you'll see brackets covering all the remaining V's in the middle. And those two LT-VEX, using the inventive technique of the patent, are intended to introduce and fix in the correct place the relevant number of V's and V's, D's and J's at either end of the locus. And we don't need to go into the details of how that's achieved, but it's done using something called mouse homology arms, which are kind of fixed on either end of the cassette and serve to locate it in the right place. The V's in the middle are then inserted by another technique known as RMCE. Again, it's not particularly necessary to understand precisely how that's done, but the teaching very much is to use these techniques to incorporate the entirety of the human IG heavy chain locus into the mouse genome. This is all set out in the patent in example 3. Examples 1 and 2 don't actually relate to the claimed invention. They're to do with the LT-VEX themselves. But the only example which is given of the invention, which is the subject of Claim 1 of 163, is this example 3. And this was the first method suggested in example 3, 2 LT-VEX and the use of RMCE to fill the gap in the middle. And the other alternative that was suggested was not bothering with the LT-VEX and just using this technique called RMCE alone. We'll come to it, but as it turned out, the lengthy description of the use of RMCE was nothing but a pipe dream. It just simply could not have been done at the priority date as held by the judge and not interfered with, in fact, not even appealed to the Court of Appeal. So that was the teaching of the patent, that you could use this technique for achieving the complete human variable immunoglobulin locus of the heavy chain in your transgenic mouse. And off the back of that description, it's perhaps not surprising that the monopoly claimed by the patentee was entirely general and extremely wide. And we set out the claim of the 163 patent in our case at tab 6 of core 1 at paragraph 79, which is MS 89. And you will get the picture of quite how broad this claim was. So it's the top of MS 89, it's at the end of paragraph 79 of our case. A transgenic mouse that produces hybrid antibodies containing human variable regions and mouse constant regions, wherein said mouse comprises an in situ replacement of mouse VDJ regions with human VDJ regions at the murine heavy chain locus, and an in situ replacement of mouse VJ regions with human VJ regions at the light chain locus. No limitations at all on the degree of the replacement, and indeed as a matter of construction it was held also to cover not deleting the mouse VDJ regions either. You just had to be able to incorporate the human regions. And the important consequence of that is what's set out in paragraph 80 of our case, which both courts below agreed. So it was set out originally in the judgment of Mr. Justice Carr, and it was approved in the Court of Appeal at paragraph 127. And this is the passage in which the judge explains the scope of this claim, and we've underlined the relevant passages, but the judge starts by noting the claim isn't confined to a single product. It includes mice in which different amounts of the regions have been replaced, includes a mouse in which 1V, 1D and 1J have been replaced. That was about the limit of the claim as held. So you had to have at least one of each. And then he says, and mice in which several such regions have been replaced. But then at the end of 4, he notes the claim extends as far as a mouse in which the entire murine variable gene locus has been replaced with the entire human variable gene locus. Now, of course, on any view, if either of the approaches in example 3 of the patent that we've been discussing had had the capability which the patent alleged, namely that they could be used to insert the entire human immunoglobulin heavy chain, therefore to produce that wide range of mice that the judge has set out, there would have been nothing wrong with a claim of the scope of the one we've been looking at. The problem for Regeneron was that its account of what could be achieved at the priority date by the methods it put forward in example 2 was wildly exaggerated, to say the least. Neither method could be used, as it turned out, on the evidence by the skilled person at the priority date to produce mice containing anything like a complete repertoire of human variable segments. As we've said, in fact, the second proposed method, the use purely of the RMCE technique, wouldn't have worked at all. The first method, the use of the LTVEX in the way that we've looked at, was ultimately held by the Court of Appeal, although not the trial judge, to have been capable of being adapted to produce something within the claim, but with a very limited number of human V segments. Nothing like that promised, or nothing like that which would have been expected and desired to obtain the full antibody repertoire. And we've set out in our case our best understanding of the number of V's, D's and J's, which on the findings of fact of the Court of Appeal would have been capable of being incorporated into the mouse genome. We've done that at paragraphs 103 to 104 of our written case at C1 tab 6, which is MS 94 to 95. There doesn't seem to be, as we perceive it, any significant dispute about those numbers. When we think that, as we say, the two mechanisms which the Court of Appeal say they were satisfied could be achieved using this mini-gene technology, could have involved introducing about 4 or 5 human V's together with an unknown number of D's and J's. So that's the ultimate position as a finding of fact in these proceedings as to the extent of enablement of mice within the range of the claim that we've been looking at the priority date, using only common general knowledge and the teaching of the patent. I wanted to look very briefly at what Regeneron did after the date of the patent, because it is referred to both by the trial judge and in the Court of Appeal. And it is worth pointing out, when we come particularly to the policy questions which are raised by my learned friends in this case, that it is a remarkable feature of this case that Regeneron had no idea at the date of the patent whether their proposed methodology could successfully be used to produce claimed mice, because they themselves had not implemented the invention at all, let alone to the full extent of the claim. They hadn't, as of 2001, even tried to insert any human variable segments into the relevant locus in the mouse genome. The invention was theoretical and the description essentially speculative. And for 2 years after the date of the patent, Regeneron struggled to get any human variable segments inserted in the required targeted way into the relevant locus. If you've got our case, which is C1 tab 6, paragraph 183, you will see a reference in footnote 44, where this is MS 113, a reference to in footnote 44 to a document produced by one of the inventors, Dr. Murphy, called Velocimmune History, and it's referred to by the trial judge in his judgment at 227 and 234. And as we point out, the first successful insertion was achieved sometime in 2003. It may be worth just turning that up. If you've got Appendix 2, tab 1, you will see this document that the judge considered at trial, and it may be worth at the same time having the judgment of Mr. Justice Carr, which is at C1 tab 5 to paragraph 227, which is at MS 325.
What is the MS of the Velocimmune history?
Sorry,
454.
325.
No, the Dr. Murphy's history.
Oh, sorry, 454.
Thank you.
And as the judge points out, if you turn over to MS 455, which is the second page in the Murphy document, and look at the first full paragraph under the heading Velocimmune, you will see a date given of December 2000, and then if you skip down to 3 lines up from the bottom of that paragraph, as being when George outlined the idea of replacing only the variable regions of the immunoglobulin genes. I said I thought it could be done. He told me he thought I was the guy to do it, and I immediately began planning how to do it. And he lists then 3 general ideas as to how to do the large replacement. And as the judge finds, the approach of example 3 of the patent, or rather the first approach of example 3 of the patent, is essentially the second of the 3 ideas that Dr. Murphy came up with, which is discussed in paragraph 2. Construct BACs, which are bacterial artificial chromosomes, with human inserts, selection cassettes, and mouse homology boxes. And what you will see in relation to this method is, if you go about 6 lines down, this method required the capability to stitch together backs to add the long mouse homology arms onto human back segments. This is essentially creating these LTVECs. And to combine multiple human inserts. Typical backs contain 100 to 200 kilobase of sequence with ends randomly located. And then he says this capability had not yet been established at the time. So this is immediately before the patent was applied for. And then it says, in addition, we weren't sure that even with long mouse homology arms, we could insert long sequences, delete long sequences in embryonic stem cells. Hadn't established the capability of creating these big LTVECs, or even using the long mouse homology arms, which needed to be used, wasn't even sure whether it was possible. And what we then get in this document is a long account of the struggles which Regeneron went through in order finally to achieve the insertion of a single back into the relevant mouse locus in an embryonic stem cell in 2003. Now that is 2 years after the priority date, which, as you'll see on MS 457, the fourth page of this document, at the end of the first main paragraph, that's just below halfway down, there's a bit of light relief. They celebrated that with a celebratory lunch at Cactus Jack's, which sounds great fun. And this is what, in fact, this finally achieved back insertion is what the trial judge refers to in paragraph 228 as being an insertion which contained a very small portion of the human heavy chain variable region. That's MS 326. In fact, that insertion in 2003 had 3 human V's in it. It's called 3HVH, and the Court of Appeal referred to that achievement in their judgment and appeared, as we'll see, to rely on the success of even this limited mouse. But we should note on this subject paragraphs 262 to 268 of the judgment of Miss Justice Carr.
So sorry, what was the Court of Appeal reference?
So the Court of Appeal reference, I'm sorry, I don't have it.
All right, don't
find it for me. Yeah, we'll find it. We'll come to it, I think. They refer to the 3HVH velocimmune mouse. But the judgment at 262 to 268 of Mr. Justice Henry Carr, which is MS 334 to 6, finds that the technique needed to make even that limited mouse used by Regeneron wouldn't have been available to the skilled person given the patent. So not surprisingly, it's not disclosed in the patent because the patent was applied 2 years before when they hadn't done this work at all. Now at trial, Regeneron argued, amongst many other things, that this technique would have been something a skilled person could have come up with without inventive capacity. But the trial judge rejected that, and that finding was not overturned by the Court of Appeal. You'll note that's paragraph 204 of the Court of Appeal's judgment, MS 218. So that was the 2 years on achievement of Regeneron. The other thing to note is that Regeneron continued to work on their project for a number of years after the priority date, and did finally manage to achieve a mouse with the full complement of the. But in order to do so, they had to pursue a new idea of Dr. Murphy and a Dr. MacDonald, referred to in the judgments as Lynn MacDonald. Again, an idea conceived in 2003, 2 years after the priority date, and which is described in the judgment of the trial judge between 233 and 238. That's MS 327 and 328. Trial judge's judgment is C2 tab 5. And you'll see this somewhat complex technique illustrated by the judge at the top of page 66 of his judgment, MS 328. But so far as we're concerned, the key passages in the judgment are 237 and 238. He refers to the evidence of Professor Stewart, one of the defendant's witnesses at trial, in relation to the MacDonald paper which described this approach as an original and elegant approach, a beautiful piece of science, an outstanding solution to the problem, and that really outstanding piece of thinking and very creative. And the judge accepts that evidence at 238. This is how Regeneron got to the complete human variable repertoire. Interestingly, even once they came up with it, they didn't publish their achievement at the time, which we think was around 2006. And when Kymab, the defendants, embarked on their development of a transgenic mouse with mouse constant and a complete human variable repertoire, they therefore had no teaching to follow. They had to come up with their own methods of achieving it, and in fact were the first to publish the achievement of the complete human variable repertoire in a transgenic mouse using targeted techniques in 2014, which was published in the world-leading peer-reviewed scientific journal Nature. And only then, later in 2014, did Regeneron publish their own paper reporting their own achievement of the same thing using the Murphy-MacDonald method. So we're now 13 years on after the priority date. Regeneron publishing their achievement using the highly creative MacDonald method, and Kymab itself producing novel and inventive techniques to achieve, although different ones, to achieve the same thing. A brief summary of the findings of fact of the judge on enablement and the extent to which they were overturned by the Court of Appeal. I suspect that you may already be aware of those. At trial, it's notable that Regeneron advanced a series of methods to answer the insufficiency case, which they alleged could have been followed by the skilled person without invention, using only his common general knowledge, to make transgenic mice right across the scope of the claim, that is to say, including the complete human variable repertoire. There were a large number of those methodologies, all of which were rejected by the trial judge on the evidence. We don't need to go through them. You've already seen the original method prompting the celebration at Cactus Jack's in 2003. That was held by the judge to use a technique that wouldn't have occurred to the skilled person in 2001. The Murphy-MacDonald technique, which ultimately enabled the production of mice right across the scope of the claim, wasn't one that would have occurred to the unimaginative person either, nor indeed could any of the other methods suggested by Regeneron have been achieved without imagination or undue effort at the date. So the judge actually, on the facts, found nothing was enabled within the scope of the claim at all, and therefore formally didn't have to consider whether some partial enablement of the claims would have been enough. But you will note, if you look at his judgment, and we'll look at the odd passage, it is suffused with references to the need to enable across the scope of the claim. and it is apparent from his account of the law and the facts that he would not have regarded enablement of one corner of the claim to be sufficient. Before the Court of Appeal, Regeneron maintained a full frontal attack on many of the judge's findings of fact, though not all of them. The upshot of which was that none of the judge's actual findings on the points which were advanced by Regeneron's experts and on the points he was asked by Regeneron to consider were reversed. What Regeneron succeeded on was persuading the Court of Appeal to accept a different case on enablement, which his own experts had not put forward, but which it said could be maintained on the basis of the cross-examination and the evidence given under cross-examination by the defendant's witnesses in relation to some of the prior art citations. And that was the potential use of the mini-gene, a small artificially created segment of DNA which can be used, or could be used, to carry a very small number of VD and J segments. And as you've seen, the Court of Appeal were prepared to accept, on the basis of the cross-examination, that such mini-genes could have been used to insert the small amounts of VD and J which we've looked at into the mouse genome, and that is what the skilled person would have done when he finally discovered that he couldn't actually implement the techniques that the patentee had told him to use. And as I say, we've attempted to summarise the mini-gene approach in our written case between paragraphs 96 and 105 and what the upshot of that was, and there seems to be no dispute of substance. So far as the findings of fact are concerned, of the range of mice which the courts below have held to be the subject of the claim, which we've looked at, stretching from one of each through to all of each, 125V, 27D, 9J, in the heavy chain, only mice towards the least effective end and the most limited end of that range in terms of combinatorial diversity were enabled at the priority date. And I should, yes, I've mentioned already the reference by Regeneron to a footnote to Professor Pleur's evidence, which is in their written case at paragraph 99, MS 158, just for completeness. We quoted Professor Pleur and his evidence about the importance of getting the complete repertoire and how that was the aim of the art at the time. Regeneron point out a footnote to that evidence at the end of 99. It has since been realised that with a limited set, we don't know how many, of frequently used human V genes, and we don't know the extent of knowledge as to what those were, which ones were needed, you can create a reasonably complete antibody repertoire. However, this was not appreciated at the priority date. We say, on the facts, A, it doesn't matter the fact is that the claim was to a range that would have been understood and perceived to be significant by a skilled person. 2, there plainly was a difference between what could be achieved with a limited repertoire and what would have been achieved with a complete repertoire. Otherwise, of course, why were Regeneron continuing to work on their mouse till they achieved the completely human variable? And why were Kymab going to the trouble of doing the same and publishing it to the world in 2014? The evidence doesn't negate that at all. And third, of course, none of these later discovered facts were known at all at the priority date, which is, of course, the date at which we need to assess sufficiency. So we submit the points irrelevant in any event. Oh, yeah. Yes, I'm reminded, I think my Lord Sales asked a question about where the reference was in the Court of Appeal to the 3 HVA. And we believe it's paragraph 100 to 101 of the Court of Appeal judgment. And at the very end of 259, which is the same paragraph that's referred to in this passage in the friend's case. So those are the facts as they come before this court.
The final sentence in 259,
Yes.
that there was immunological response which was close to that of wild-type mice.
Yes.
Is that saying more than the immunological sickness problem was cured?
No, we don't think it is. It's not talking about the repertoire problem as a point that we make in our written case. It's a somewhat vague statement, but that's certainly how
I was wondering what its scope was, but perhaps we can hear more later.
Is it not also talking about, just in the light of the previous sentence, is it not talking about the degree of human antibody expression? I mean, the point being made is if you only have a few human gene segments, V segments, then the response of a mouse isn't going to be very different from that of an ordinary mouse.
We think it's talking about the effectiveness in terms of production of B cells, rather than the variety of the repertoire that can be produced, insofar as one can get anything out of it. Yeah. Yeah. Yes. We think it's a reference. In fact, you can probably see it more clearly if you go back to paragraph 100 and 101 of the Court of Appeal judgment.
You give me a page.
I think it's, sorry, that's MS 196.
Yep.
And you'll see there in the middle of that page, and bear in mind that they were obviously trying to deal with the immunological sickness problem. They simply say the B cell response of these mice was far closer to that of wild-type mice than competitor mice. But of course, ultimately we say this is all ex post facto. There's not an awful lot about it in the evidence, but what is absolutely clear is that at the critical date, which is the date of the patent, everybody wanted to make mice with the complete repertoire, because for the reasons I've given you, that's going to produce, both theoretically and in fact, the biggest range of antibodies. And that's indeed what the industry continued to work on for years after the priority date. Can I turn to the law now and the fundamental requirements of sufficiency under Article 83 on its face states that the invention must be disclosed in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art. Now, the required disclosure from which the person skilled in the art must be able to carry out the invention is what is commonly referred to in the authorities as enablement. And that's how I'm going to refer to it in the course of these submissions. The requirement of enablement, of course, is critical to the bargain between the patentee and the state, which is the theoretical underpinning of the patent system. The theory reaffirmed in recent times by my Lord Hodge in Actavis and ICOS, and in fact by Lord Sumption in Generics and Warner-Lambert in passages that I don't need to trouble you with. The point is, it's not enough, so far as the state is concerned, for the inventor simply to come up with a good idea. He's got to provide the technical teaching to enable the skilled reader of the patent to perform according to the monopoly claimed. And the tools which the skilled reader is deemed to have to do that job are what's in the patent and his or her own common general knowledge. And it must be possible using simply those tools to implement the invention at the priority date without invention. That is the basic statement of enablement which Lord Justice Jacob referred to in Novartis and Johnson & Johnson in the passage quoted by the Court of Appeal at 230. So far I'm not touching on scope of the claim. So we're just talking about the extent to which the skilled person needs to be able to make at least something within the claim. Now there are 3 points that are probably worth making on this, because they come back when we look at some of the later cases and maybe relevant facts. The first is the question of date. Enablement has to be judged as at the date of the patent, here 2001, and that's a point made very clearly by the Technical Board of Appeal in the Salk case, in a passage which was cited by the Court of Appeal in Generics and Warner-Lambert. If you've got authorities for tab 26, yeah, paragraph 32, it's MS 2021. You'll see the relevant citation, which gives both the principle and the reason for it. Sufficiency of disclosure must be satisfied at the effective date of the patent, i.e. on the basis of the information in the patent application together with the common general knowledge then available to the skilled person. Acknowledging sufficiency of disclosure on the basis of relevant technical information produced only after this date would lead to granting a patent for a technical teaching that was made at a date later than the effective date. And then there's a reference to the technical contribution to the art, which we're going to come back to. A second point on the basic requirements of enablement. You will recall that Article 83 refers to the need for sufficiency by reference to the invention. It is well established that the invention means no more and no less than what is defined by the claim of the patent. And the best reference for that is Lord Hoffman in Generics and Lundbeck in the Court of Appeal, which is at Authorities 2, tab 12, paragraph 29. MS 1255. Having set out Article 83, or rather Section 72(1)(c), which recites it, at paragraph 29, he says, in order to decide whether the specification is sufficient, it is therefore first necessary to decide what the invention is. That must be found by reading and construing the claims in which the inventor identifies what he claims to be his invention. And then there's a reference back to Exxon fuel oils, a case we're going to come to. It is the definition of the invention in the claims that needs support. I could also refer to Section 125(1) of the 1977 Patents Act, which defines invention in the same way. The third point is, what do we mean by being able to carry out or perform the invention? When one comes to certain passages in the judgment of the Court of Appeal, this apparently simple question will become important, because we submit, in the case of a product claim, this is in fact a very simple question. Performing the invention means being able to make the product. And we get that, if we need authority, again from Lord Hoffman in Generics and Lundbeck, which is A2 tab 12, which we were just looking at. Sorry, I should have told you not to close it. At paragraph 30, the immediately succeeding paragraph on MS 1255. Section 60, subsection 1 of the Act makes it clear that a claim may be either to a product or a process. In the case of a product claim, performing the invention for the purpose of Section 72(1)(c) means making or otherwise obtaining the product. In the case of a process claim, it means working the process. The product claim is therefore sufficiently enabled if the specification discloses how to make it. There is nothing to say it must disclose more than one way. We'll come back to that, which is another point that somewhat bedevils the judgment of the Court of Appeal in the present case. Just to expand a little on the proposition about what performing the invention means, there are a variety of different forms of claims that one comes across, and particularly comes across in the authorities cited in this case, other than product claims. First of all, process claims, and Lord Hoffman's dealt with that in a straightforward way in paragraph 30. You obviously have to enable the skilled reader to carry out the process with the features set out in the claim. We also find claims which we call product by process claims, in which a product made by a particular process is defined. And here, enablement requires you to be able to make the product with the features of the product claimed, using the process with the features of the process claimed. This can be seen again from Generics and Lungbeck, Lord Hoffman, this time at paragraph 34 on MS 1256. He's talking here about the particular issue that arose in Biogen, which, as he says in paragraph 34, was construed by the House of Lords as a class of products that satisfied the specified conditions, one of which was that the molecule had been made by recombinant technology. In other words, it was a product by process claim. That expression obviously includes a wide variety of possible processes, but the law of sufficiency is that a class of products is enabled only if it can be worked in respect of all members of the class. The specification might show this has been empirically demonstrated and might disclose a principle, but the specification in Biogen described only one method of making the molecule by recombinant technology and no general principle. It was easy to contemplate other methods about which the specification said nothing and which would owe nothing to the matter disclosed. So in other words, as was confirmed in the House of Lords, where you have a product by process claim such as the Biogen claim, you have to enable the skilled reader to make the product with the features of the claim using the claimed process. And any questions of breadth of claim, which we're going to come to, have to be read accordingly. So those are the most, in a way, the simplest claims: product, process, product by process. What we come across commonly on questions of sufficiency, however, are claims which include the performance or achievement of a particular effect. And they give rise to a slightly different problem. And the most familiar example, which the courts will have seen and this court has seen, are medical use patents, in which a known chemical entity is patented for use for the treatment of a particular condition. Of the kind considered by this court in Warner-Lambert, of the kind that we will see were an issue in Regeneron and Genentech. Enablement there requires not only that you can make the product, but it does in fact work to treat the condition in question. So in Regeneron and Genentech, which we'll come to, there the products not only had to be able to be made, but they had to be suitable when made for the treatment of a non-neoplastic disease characterized by excessive neovascularization, which was the way in which the claim was drafted. And the point I'm making is that the nature of the inquiry as to what is required to be enabled is sensitive to the type of claim, and one needs to bear in mind what type of claim we're looking at when one turns to the authorities. And the final point I want to make generally before, which relates to the last one, is you will note that Lord Hoffman in paragraph 34 that we have just been looking at uses a phrase in the 6th line where he refers to the skilled man being able to work the invention in respect of all members of the class. He uses the phrase working the invention here as a synonym for performing the invention. And we will see that commonly used in the UK authorities, though not so much in the TBA. In relation to product claims, they say, can the invention be worked across the claim? And the point that we make in the case, which I would ask you again to bear in mind, is that asking if the invention can be worked is not the same as asking if a product within the claim would work in the sense that it would have some useful quality if it could be made. That latter question, would the product work, is, we submit, only a relevant question to sufficiency if the useful quality in question is an element in the claim. A classic example is the medical use type claims. Can these chemical entities, when made, be used to treat the condition which is the subject of the invention, the claim?
Well, what do you say this is? In Biogen, what Hoffman's talking about there is what he calls a hybrid product by process claim.
Yes.
As distinct from a simple product claim.
Yes.
And so we're dealing here with what?
We're dealing here with a product claim, and the only issue before the court is whether the products can be made.
Yeah.
And it's easy to get distracted, and with respect to my learned friends, they use this language in quite a distracting way when one sees references in authorities where the useful feature is a part of the claim that say, will it work? And of course, that's a perfectly respectable question to ask in a medical use case. And indeed, usually it's the only question the court is having to ask, because it's assumed that you can make the chemical entities. The real problem is, do they work to treat the condition? And that's not relevant here, because we don't have a claim which incorporates a function or useful feature. So in this case, reducing immunological sickness, for example, is not a feature of this claim at all.
I think I'd picked up that claims 5 and 6 in patent 247 were described as product by process claims. Is that right?
No. They are I think they're very extraordinary claims, actually. They are claims to products which are obtainable by a process. But that was construed so widely as to incorporate products, of course, not made by that process at all. Simply products that had the same characteristics in terms of their physical makeup that they would have if you had made them using the kind of process which is in example 3. In other words, they are essentially product claims because there is no relevant limitation as to how they can be made. So I think if they were referred to as product by process claims, that would not be an accurate reflection of the nature of those claims. They're very, very odd claims, and they were construed remarkably widely because, for example, they were held to cover products which would have been obtainable by the process taught in the patent using techniques which didn't exist at the priority date. In other words, they were construed sufficiently broadly as to cover anything which fell in Claim 116. We refer to that somewhere in our written case. After the adjournment. So that's those are the various points that I'll come back to on a number of occasions when we look at the authorities as to what the courts are actually looking at.
Well, you can come back to it later, but if you look at your case at paragraph 82 MS, page 89, it seems to suggest that when you're talking about claim 1 of 163, you describe it also as a product by process claim.
Yes, in a very loose sense. If one looks at the claim, it is, as we say, it requires a product in which those regions have been replaced. There's no limitation to how you get there. So we say that certainly doesn't help Regeneron. It makes their case worse, if anything, because as we know, for a product by process, you've got to enable not only products across the scope of the claim, but to be able to make them using a range of processes. We haven't taken the point specifically on this appeal that in fact there isn't enablement across a wide range of processes. We're limiting ourselves to the product side of it. But your Lordship's quite right. It is technically, because of the reference to replacement, it does have a slight process component to it. But in our submission, that doesn't actually affect the issues on this appeal. Essentially, it's even a claim to a transgenic mouse is implicitly involving some kind of process, because we know that to get there, you have to have made it artificially. A bit like biology in that sense. But the process isn't actually an issue before you today. Can I now talk about enablement across the scope of the claim and the relevant law on that? Where a claim is to genuinely a single product and not a range, then there is no difficulty. One simply has to enable the particular product which is the subject of the claim. Such cases are in fact quite rare because patentees, as we point out in our written case, almost invariably define their invention at a level of generality. But there are cases to that effect, and Generics and Lundbeck was one of them. As we point out at paragraph 19 of our case, it was to a single chemical entity and therefore had no scope beyond that particular entity, and provided that particular entity had been enabled, that was all that was held to be required. But how do we deal with the case where one has a generalised claim to products which go beyond a single entity and encompass a range of potential products within the scope? It's fair to point out that in the early years of the EPC, both in the EPO and in the UK courts, there was a measure of controversy as to whether enablement needed to exist across the whole scope of the claim, or whether only one product within the claim needed to be enabled. That was enough. And there are UK authorities which followed the single product only needed route in that dichotomy before 1994, including Chiron, for example. But the matter was clearly resolved in both jurisdictions around 1993 or 94 in favour of enablement right across the scope. And we submit the policy reason for that is pretty obvious. Why should a patentee be able to sustain a claim to any of A, B, C, D, or E, or to a range including A, B, C, D, and E, when he's only enabled the reader to make A? In those circumstances, individual claims to B, C, D, and E would inevitably have failed, and it would seem quite strange if the patentee could nonetheless maintain a monopoly by creating a compendious claim that covered all of them.
Yes, the bargain is the monopoly is determined by the claim, and the monopoly must reflect the inventive contribution.
Yes, because of course, the bigger the monopoly, the more the state is giving
Yes.
the patentee, and the more he needs to give back to it, put in that way. But more, perhaps just as importantly, such claims would stymie research and development by third parties, of course, to achieve B, C, D, and E, because the dead hand of the state monopoly would prevent it. The policy we submit is clear and undeniable, and the legal statements of the basic principle are multitude. We've taken in our case the 3 standard citations on the subject from the TBA, which we have reproduced in paragraphs 23 through to 25. And just to look at those briefly, it's MS 74. The first reference we give, which is chronologically the first one, which is a case that is reasonably commonly cited, is called Stable Bleach's Unilever. These case references, this one, T22685, 85 is actually the year when the appeal proceedings began. It doesn't actually reflect the date on which the decision is given. So ditto below 91, detergents Unilever, and 91 fuel oils Exxon were only in fact decided in about 93. But the first reference, Stable Bleach's Unilever, was actually at the time when there was this divergence of approach, and it wasn't clear which way the TBA were going to jump. But in this case, the position was clearly set out as being understood by the board to mean that substantially any embodiment of the invention, as defined in the broadest claim, must be capable of being realised. And what follows in 24 and 25 are the 2 cases which, if one presently looks at decisions of the TBA, they are quoted, as it were, as the twin pillars of sufficiency, often just referred to in brackets as authority for position. And detergents Unilever, which is the first one, as we shall see, actually went through the existing chain of authorities, because in that case it was being specifically argued that enablement of a single embodiment was enough, and sought to resolve the disparate statements which one had previously found in the decisions of the TBA. And in this decision, you will see the way it's characterised is that the whole subject matter that is defined in the claims, and not only a part of it, must be capable of being carried out without undue experimentation or inventive ingenuity. Undue experimentation is what we sometimes call undue burden, and inventive ingenuity plainly is invention, and we'll see those in the summary of Lord Justice Jacob, which we'll come to. And thirdly, the Fuel Oils Exxon decision, which is probably the most commonly cited in this field, in order to fulfil the requirement of Article 83, must contain sufficient information to allow the person using his common general knowledge to carry out the invention within the whole area which is claimed. We have given a fairly lengthy account of this case in our written case, so you're probably familiar with essentially what's going on there. But we've done so because it is so oft cited and because it is a paradigm example of a claim to a range of product, as it were, from top to bottom. And the claim in Exxon, and we set out the basic facts in our written case from paragraph 28 onwards, MS 75 to 6, was to a fuel oil in which the wax crystals that tended to occur in fuel oil and blocked engine filters had an average particle size of less than 4,000 nanometers. And the idea was, if you had very small wax crystals, they would obviously pass through the holes in the filter and make it less likely to block. But the claim, and this will become a relevant point, you will note in paragraph 29, was to the fuel oil itself, with certain wax content characterized by the fact that the crystals had an average particle size less than 4,000 nanometers. This was a pure product claim. And what happened there was, plainly there was a range claimed, which the skilled reader would recognize because it covered fuel oils with a crystal size of 4,000 down to crystal size of less than 1,000, indeed, presumably right down to 1 nanometer or less. And at the hearing, the applicant recognized that he hadn't enabled the manufacture of any fuel oils with crystals less than 1,000 nanometers in diameter. And the upshot was he recognized that this rendered claim in its wide form invalid, as not being enabled in its scope, and sought to save it by limiting it to fuel oils with a crystal size between 1,000 and 4,000 nanometers. And the first important point to draw from this case is that the Technical Board of Appeal held that this was a required amendment, that plainly the claim, insofar as it covered fuel oils with crystals less than 1,000, which had been accepted not to be able to be made, was invalid to that extent, and that the proposed amendment was therefore necessary to make. That is the first element in the decision. It might be helpful for your lordships just to turn it up. It's in A4 tab 33. Yeah, A4 tab 33. MS 2319, it starts. And in respect of this point, you will see, if you turn to page 2, which is the introductory part of the decision, you will see from the bottom of page 2, the last two lines, that's MS 2322, the last two lines. In respect of Article 83, the appellant admitted the application did not contain any disclosure enabling a skilled person to obtain fuel oils of a claimed type containing wax crystals of an average particle size of less than 1,000. In his opinion, it wasn't necessary to indicate a lower limit of particle size, since the solution of the technical problem was the indication of a suitable upper limit. So the lower limit wasn't an essential feature of the invention. But the decision of the Board of Appeal was, as we set out, that this was in fact a necessary requirement in order to narrow the claim to what was actually enabled. So you'll find that on page 5 in relation to the main request, starting about 8 lines down, MS 2325. So there's absolutely no doubt all the claims must be construed to relate to fuel oils containing wax crystals smaller than 1,000. By relate to, they must plainly do mean cover. The appellant has admitted that no way of obtaining those oils was disclosed that could be found. In the board's judgment, in order to fulfil Article 83, the application as filed must contain sufficient information. And this is the general statement of enablement across the scope to carry out the invention within the whole area that's claimed. Therefore, the decision under appeal correctly found the claims of the main request related to an invention which was not sufficiently disclosed as required by Article 83 EPC. So range was 0 to 4,000, accepted that 0 to 1,000 couldn't be done, duly had to be excluded from the claim on the basis of insufficiency. What actually then happened was he also lost his claim to the more limited form of between 1,000 and 4,000 because he hadn't enabled all crystals within that range to be obtained either. He'd only specified the use of one particular additive which would produce one particular form of crystal, and therefore it was not even enough to support the narrower claim range. But so far as illustrative of range issues, this is the classic finding that you've got to enable across the whole range. So far as the UK is concerned, that approach was immediately adopted, and the first time one sees that being adopted was in fact the Court of Appeal in the Biogen case. I might just briefly take you to Lord Justice Hobhouse in that case, which is at A1 tab 4, pages 98 to 99.
So sorry, I missed the reference.
I'm sorry, my lord. It's Authorities 1, tab 4, page 98 of the decision.
Have we got the electronic?
And it's MS 913 through to 914. It's an old case where there are no paragraphs, so I'm using the pages of the report in the RPCs. And Here, Lord Justice Hobhouse has cited Exxon, which you will notice is the long quote at the top of 98, notes that that decision directly addresses the relevant question, which is, do you have to enable across the scope, or is one product sufficient? He says, in our judgment, what the board has said correctly represents the law. It's not the law, as you see at 42. The disclosure of a single embodiment will always satisfy the requirement, regardless of the width of the claim. And then you'll see Mr. Laddie, for the plaintiff, modified the submission. He argued that where the patent related to the invention of a principle, the enablement of a single embodiment of that principle would suffice. He thus went some way towards accepting what we've held to be the correct view of the law. But that doesn't advance the plaintiff's case unless he can show that claims in the patent have that character and are so limited. This he cannot do. In the present case, the patent makes claims to product, and most of the claims are very widely expressed, cover both core and surface antigen and any host. And then he says the disclosure must be wide enough to enable the man skilled in the art to perform the claimed invention across its full width, not just by reference to one type of antigen, one type of host. Plaintiff had a choice how widely it would draw its claim. If it chose to draw it widely, it must accept the correlative obligation to make a correspondingly wide disclosure. Unable to make that shows it's seeking to claim a function it's not entitled to. Follows actually Lord Justice Mustill in Antec. And since then...
And what would be an example of an invention of a principle?
I'm going to come to principle because it's so central to everything my learned friends say.
All right.
And in a nutshell, we say to be relevant to enablement, a principle must be an enabling principle. And one gets those. I mean, one can have enabling methods which, in fact, enable the invention to be performed right across the scope of the claim. If a particular principle is sufficient to enable the reader of the specification to achieve that, then it will be properly enabled. What isn't enough is a principle that simply reflects the benefit that you would gain if you could make the product. We say that can't possibly be relevant to enablement because it doesn't teach you how to make the products. But I'm going to come back to this in some more detail because it is so fundamental to the dispute between the parties. So yes, numerous references adopting the same approach, of which I would only ask you to look perhaps at Lord Walker in Generics and Lundbeck, which is at A2, tab 13, paragraph 20. MS 1272. So from about 5 lines down, the disclosure must be such as to enable the invention to be performed, and then he says that is to be carried out if it's a process or to be made if it is a product to the full extent of the claims. The question of whether there is sufficient enabling disclosure often interacts with the question of construction as to the extent of the claims and refers then to American Home Product and Novartis. The disclosure would have been insufficient if the claims had extended not merely to rapamycin, a known antifungal antibiotic, which proved effective as an immunosuppressant, but also to derivatives of rapamycin, which he might have added in brackets, which didn't. The Court of Appeal held that the claims should be narrowly construed and on that basis there was sufficient enabling disclosure. So that was another example of a claim in which the effectiveness was a feature. You had to show that rapamycin had the effect of being an immunosuppressant, and they couldn't do that for the derivatives. But because it was narrowly construed, it was valid, but of course it also meant it wasn't infringed. So it wasn't much use to them in the end. And we submit that the trial judge's summary of the law on breadth of claim enablement, as it's applied in the UK and the TBA since 1994, which is summarised at 208 to 214 of the trial judgment, CV2 tab 5, cannot be faltered, and in particular we would cite paragraphs 211 to 212 of that section, MS 322 to 3, where the judge sets out the various authorities cited by Lord Justice Jacob in Novartis and Johnson & Johnson by reference to that decision, which include Unilever, which include Mycogen, claims not allowable if they encompass subject matter, which in the light of the disclosure can only be performed with undue burden or inventive skill, and Ineos amorphous silica, sufficient guidance for performing the invention without undue burden over the whole range claimed. And then finally, Lord Justice Jacob in the Novartis quote, which we will see the Court of Appeal wrestling with in their judgment at 230. It may be worth also, while we're there, just noting the quote from Lord Justice Kitchin himself in Regeneron, that is to say Regeneron and Genentech, the 2013 case, making exactly the same point, and in particular noting first of all that the scope of the monopoly must correspond to the technical contribution, and then saying an aspect of that requirement is that the specification must enable the invention to be performed to the full extent of the monopoly claimed.
There's no mention in the authorities that we've looked at so far of the concept of a principle, except in Mr. Laddie's ingenious submission.
Yes, well,
I think we saw Lord Hoffman mentioned it in a case that was it Biogen?
I did mention it in Biogen. I'm going to come back to, I'm sorry, I keep hanging this kind of bait out, and I'm going to come back to principle, given how important it appears to be. We submit there are some disparate references to principles, but one actually sees what the TBA mean when they talk about relevant principles in this context. They are talking about principles that actually enable the performance of the claim across its scope. And we submit actually Lord Hoffman wasn't saying anything different.
Well, the specification has to enable the invention to be performed.
It does, and how it does that is a question for the patentee, and it must be assessed as a question of fact. Sometimes very general methodology is enough, given the skills of the team who are going to be reading the patent, to perform the invention, to make a wide range of products according to the invention. Polypeptide expression is a very good example of that when we come to it. But in other cases, that is simply not so. One needs to be very careful as to precisely what has truly been enacted.
Would you help me if we went right back to basics and you were to reiterate what the invention is here, what the range is,
Yes.
and what bit of the range is not enabled. I've got the claim at page 52 of the
Yes.
original trial
Yes.
judgment, for example.
The range is,
First of all, the invention,
the invention is what is in the claim
the transgenic mouse with the
with
various...
placed with the VTJ human, with the urine VTJ regions and the heavy chain and the light chain replaced
Yep.
with
Something
human
said in
VTJ.
generic
region.
Lundbeck.
The scope of that claim is common ground because both the judge at first instance and the Court of Appeal expressly set out what the scope was, and we set that out in paragraph 80 of our written case. So it extends from a mouse that has one V, one human V, one human D, one human J in its heavy chain lockers, to a mouse that has 125 Js.
Bees.
Sorry, Vs, beg your pardon. 20 odd Ds.
The whole human
and
complement.
6 Js.
I think you said 27 Ds previously.
I'm grateful. I forget the precise
Well,
numbers.
don't quote me on it.
No, very
back to you what you
The odd
said.
thing about this case is that even the experts say things like about 120. So
But is the point, it's the whole human
the
complement.
whole, all those numbers. So in numerical terms, even if one assumes that that the Court of Appeal had found that all the Ds and Js could be squeezed into their mini-genes, and they don't, but let's just make that assumption and look at the Vs. 5 Vs are enabled.
Yes. So,
Anything beyond 5, between 5 and 125, is not.
yes, looking at the I'm looking at it in a big picture way
Yes.
at the moment. And so the Court of Appeal found that using the mini-gene method, you could create a mouse with a relatively small amount,
Yes,
and the Kymab mouse has got the whole lot.
not the whole lot.
And so your argument is that it is not enabled, it only enables the small mouse.
Yes, I mean, not only that the Kymab is not enabled, but if one imagines the claim as covering a mouse with 1J, 2Js, the whole range of mice, anything from 5 upwards is not enabled. So the mouse with 10 is not enabled, the mouse with 20 is not enabled. Sorry, V. The mouse with 50 is not enabled. The mouse with 105. That actually is, if one was to write the claim out, to list the entire range of what's covered, then that is what one would write down, and one would effectively draw a line at a certain point around
So
5.
as in exon terms, anything below 1,000.
We say it's precisely the same. In a way, we'll make the submission that this is a very easy case. It's a paradigm case of a range, partly because both courts below have expressed it as a range. The claim extends from here to here, and one knows roughly where the enablement line is drawn. And really, on any straightforward view, that is the end of it. The claim needed to be limited to where that line could properly be drawn. There might have been some arguments about 5, 6 or 7, but at some point, enablement stopped.
The principle is a mouse with remaining mouse constant and human variable.
Well, that certainly is the principle of the claim, and in fact it is the claim. That's what the claim says, but if it's not enabled across its scope, the fact that one can say it's a principle doesn't save the patentee. Because after all, in exon, one can say the principle is small crystals, less than 4,000. However small they are, in fact, the smaller the better. They're all going to work. The problem was not that there was no common principle or that the principle wasn't useful. The problem was that the principle couldn't be enabled, couldn't be performed across large parts of the scope of the monopoly.
But I thought that in Exxon, then you already knew that it had to be below 4,000.
I was going to come. It's a good time to look at it because that is indeed one of the points that Regeneron make, and it's a bad point because if one looks at.
Sorry, I don't want to take you out of
Your ladyship's way ahead of my analysis. So let me just deal with it briefly.
I wonder, can we just break things a little bit?
Yes.
Because we're using the language of principle without having even attempted to define what the concept is.
And I am going to come to it very shortly.
Yes, well, just when I mentioned Lord Hoffman and Biogen, it was in fact Lundbeck at 34 where he referred to Biogen that he used that phrase.
That's right.
Yeah.
And he also went back to it again in Kirin Amgen, where he sought to massively play down the whole idea of principle.
Well, I won't take you out of sequence, but I just wanted to correct my false reference.
I could very quickly just finish that point that Lady Black made. At 3.6 of Exxon, so it's A433. You will see that whether or not they'd invented the principle of smallness, A433, page 12 of the bundle, MS2332. So this is having made their finding of insufficiency. So if you will see at the top of 12, the present case is comparable to cases where a group of compounds is claimed and not all of them can be prepared. In the latter case, it was insufficient to disclose a method of obtaining only some members, hence, etc. So they find insufficiency. And then in 3.6, you'll see critically, they say this. For these reasons, the auxiliary request must fail regardless of whether or not the alleged principle to avoid the so-called cold filter plugging by reducing the size of the wax crystals would be novel and inventive. In other words, it didn't matter whether he could claim to have invented the idea of small crystals. The problem was he hadn't enabled them across the scope of his claim. Now, the other side, right, there's then a kind of an incomplete reference where the TBA said right at the end, the appellant has admitted that it was possible to construe the meaning of the, in his opinion, ambiguous statement of the prior art in such a way as to disclose that principle. They don't actually make a finding one way or the other. But the reason for that is that they don't need to, because as they've said, it doesn't matter whether the inventor in Exxon could claim to have discovered that principle for the first time. It didn't affect the law on enablement. Sorry, I am jumping around a bit, but I thought it was useful.
My fault, sorry.
That point, because you are way ahead of me. So that's the essential statement of breadth of claim enablement. We've seen several versions of it, but they're all essentially to the same effect. I was just going to make two brief points on how that rule is applied before turning to the result of this case and how it was who got it so wrong. The first is you'll see in a number of these authorities a reference to substantially all products within the scope. Of course, like most legal rules, there is some flexibility and it's not taken to extremes. And in each of the citations we've looked at, there is a reference to substantially all. So in detergents, Unilever, substantially all embodiments a skilled person would envisage. Unilever stable bleachers, substantially any embodiment must be capable of being realised. Exxon, substantially all embodiments falling within the ambit of the claim. So this is to stop losing claims as a result of speculation about whether the very furthest edges of the claim could be actually achieved when the patentee had never suggested that they could, or some imaginary product that might be thought to fall technically within the claim and might not be able to be enabled. That kind of thing is dealt with by saying, well, it's a rule of substance. It obviously needs to be applied sensibly. The second point is that, and this is a critical point where we say the Court of Appeal fell into error. In the case of a product claim, the fact that you have to enable products to be made across the whole scope of the claim doesn't mean that you have to enable all methods of making those products across the scope of the claim. So if you can provide a single general method that enables a skilled person to work the invention across the whole scope of the claim, that's perfectly sufficient. You don't need to enable all other methods of achieving the same thing. And that was the jurisprudence of the House of Lords in Generics and Lundbeck, where Mr. Justice Kitchen, as he then was at first instance, had wrongly found a product claim to a single chemical entity invalid because only one way of making it had been disclosed. And it was held ultimately that that was a misunderstanding of what Lord Hoffman had said in Biogen, because the extra requirement of sufficiency of that kind only applied in product by process claims like the one in Biogen. But for present purposes, the point that I want to make is, and this is where we'll see the Court of Appeal fell into error, the fact that you don't need to disclose all methods of making products across the scope of the claim doesn't dent the fundamental principle that whatever methods you do disclose must enable substantially all products across the scope of the claim to be made. That wasn't, as it happens, a problem in Generics and Lundbeck because it was a genuine single product claim and it was fine. But if your preferred method is not adequate to enable across the breadth, you either have to limit your claim or you have to disclose additional methods that would enable the products. And that, of course, was exactly the case in Exxon. He'd only described a single additive capable of making particular crystals. There was no evidence or teaching as to how to adapt that to make different crystals, and therefore the products which were the subject of the claim were not enabled across the scope. And as we'll see when we come to the Court of Appeal judgment, they a number of times characterise Kymab's argument as if we were saying that you needed to have disclosed all the methods that would enable. We weren't saying that at all. We were saying your method doesn't enable the products to be made.
Now,
I see we're running over time.
is that a convenient moment?
That's great.
Very well, 2 o'clock.